Thank you so very much for that introduction, and good morning, everyone. I am delighted to be here this morning. And this morning, we are going to have a conversation. And so I'm not going to use any slides because we're going to be talking with each other about our experiences and what we have encountered in the boardroom. Is everybody hearing me okay? Yes, I see some thumbs up. All right. So I entered the boardroom a long time ago. This was 1982. I was 22 years old and I had just left law school. A major not-for-profit organization asked me to be their honorary secretary because, of course, once you're a lawyer, you know how to be a secretary. We know that's the case, right? Once you're a lawyer, you know how to be a secretary. There could be nothing further from the truth. So I said, well, what am I supposed to do? And they said, well, you have to make sure the minutes are recorded accurately because there was a recording secretary. Make sure we're complying with the Companies Act and sign the contracts. So I thought about it and I said, that seems easy enough. I can do that. And that was my entree into the boardroom. And I have been there ever since. And it has been an amazing experience. I was working at the bank at the time. And after 4 years there, also being the corporate secretary for this entity, it was the National Foundation of Jamaica, I was then headhunted into my next job, which was as the corporate secretary of a major bank. It was called Citizens Bank at the time. I was head of legal and corporate secretary. How they took such a young person and go put me in that position, I still wonder. But I was very happy to be there. And Citizens Bank today is now known as Sagicor Bank. And thereafter, I moved to Cable and Wireless as regional vice president and corporate secretary. Now, I tell you this history because I wanted to demonstrate that I've been here for a while. And this role has metamorphosized in that period. What it is today is not what it was when I first entered the boardroom. And this metamorphosis that the role of corporate secretary has undergone obviously parallels what has happened with the directors because it is one board. And as the role of the directors has changed and grown, so has the role of the corporate secretary. In 1887, Lord Esher, in a decided case, said, a secretary is a mere servant. His position is that he is to do what he is told, and no person can say he has any authority to represent anything at all. That was 1887. 84 years later, 1971, Lord Denning said, a company secretary is a much more important person now than he was in 1887. He is the chief administrative officer of the company with extensive duties and responsibilities. He regularly makes representations on behalf of the company and enters into contracts on its behalf. So we could see the role had evolved so much over that period. Then you hit the 1980s, flowing through into the 1990s, when we began now to have these major corporate scandals, whether it was Polypec or Colorol in the UK, and companies that previously were perfectly good companies as far as everybody was concerned, they were suddenly declaring insolvency, suddenly being found going insolvent without any public forewarning. And the financial sector and investors' confidence was shaken by this kind of an occurrence. So the Cadbury Committee was established, chaired by Sir Adrian Cadbury in May 1991. And out of that came the Cadbury Report, which many of us would be familiar with. because that was the first step on the road to what is today the UK Corporate Governance Code. With that code, the role of the secretary continued to evolve because the role of the board evolved. There were no certain requirements that were put in place. And across the pond in the US, in 2001, you had Enron. And when they filed for bankruptcy, it was the biggest bankruptcy up to that point in time. Shareholders lost $74 billion. Employees lost over $2 billion in pension benefits. Can you imagine having been an employee in Enron and you not only lose your job, but you lose your pension because your pension fund was invested in Enron shares? And since then, we've had WorldCom, Lehman Brothers, Washington Mutual, and you can continue to name them. So, of course, the response, there had to be a response, and it was Sarbanes-Oxley, which brought in all sorts of provisions, which some of which have been rolled back. And we here in the Caribbean, we were not immune to what was happening in the US and in the UK. And here in Jamaica, we certainly had our own financial sector crisis in the latter part of the 1990s. So I was in banking at the time that we had our financial sector crisis. I was the corporate secretary of a company called the bank called Citizens Bank, which was a publicly listed bank. And I can tell you, it was terrifying. One bank in Jamaica had done things which it ought not to have done. And obviously, they were poorly governed. The government moved in on that bank. And what happened was that persons got concerned about the operations of local banks. And that caused a run on the banks. Now, banks operate by taking deposits from our depositors, and then we lend that money to our borrowers. Now, if all our depositors decide to come for their money at one time, there's a problem because we don't have it sitting in the vault waiting to give the banks back. It's loaned out to customers. So when that happened and there was a flight from the local banks to the international banks, the government then had to step in to shore up the local banks. And it was against that background with the local financial sector crisis that the PSOJ in 2001 looked around and said, okay, what do we need to do to shore up governance in Jamaica? And they set up the PSOJ Corporate Governance Committee in 2001. And by 2006, we had our first corporate governance code in Jamaica. And I think it was the first code in the Caribbean. And I want to pay respect to a woman named Greta Bogues, who was the principal architect behind that code. Greta passed away earlier this year. So having gone through and taken you through that history, I wanted to share with you what I have learned over these many years. But I also want you to share with me and the rest of us your take on my learnings and also what you have learned in relation to those particular issues. And I'm so happy to hear Kamla say that she's thinking about a forum for corporate secretaries because I think that one is long overdue. We do have our Chartered Secretaries Association, but then if you're a lawyer acting in the role with the job as corporate secretary, you don't belong to that association. And so very often you are excluded. Now, how many people this morning are corporate secretaries? How many people? Can you just put up your hands? Let me have a view of how many secretaries we have in the room. Okay, Renuka, yes. Francis, yes. Sasha, yes, I'm seeing the hands. Chanel, okay, great, great, great. Yes, I'm sure there are more. Julie James, where are you? June Fowler, right, June? Okay, so there are many of us. And so we are all going to co-present this morning. I know you didn't come here to co-present. So this is a surprise. And CCGI does that kind of thing, right? We push the envelope and there we try new things. So let's start at the beginning. Board selection. Do you, for your respective companies, have your board competency profiles? Those competency profiles that say, for this organization, doing what it does, we need to have people with these particular skill sets, because that's where you start. And as a corporate secretary, you will know that very often when those selections are being made, the chairman comes to you and says, who do you think? Who can you recommend? So you have an opportunity from the get-go to help very often select the persons who become a part of that board. Now, in public sector, we in Jamaica have recently mandated that there must be a board competency profile. And in fact, our Ministry of Finance has developed board competency profiles for each entity, or certainly the basic skills and some of the particular skills which must be there. But then each entity would go through and say, does this competency profile give me all the skill sets I need? And so in our annual reports now, you will see competency profiles put in there and indicators as to which competencies are there present in the board. Christy, put up the Enron board for me. I just want, we're going to have only 2 slides today. And this is one of them. This was the board of Enron. Does anything jump out at you?
Look at all those suits. One woman.
Yes. Only one, yes.
Brenda? Come, I want to hear your voices, folks. What? Yeah. So diversity.
Right. No diversity.
Diversity is lacking.
Completely lacking.
Yep.
A bunch of old, elderly Caucasian men. And one little lady. And of course, you know, they say it takes at least 3 women to have a voice, unless, of course, there are some of us now who by ourselves, we are 3. But this was the board. Christy, the next one. Who were these people? Christy, my next slide, please. Yes. So these were important people. These were knowledgeable people. Chairman of Belco, President and CEO of Comdisco, Chairman of Hang Long, former Chairwoman John Wakeman, former UK Secretary of State and member of the House of Lords. He was also on the audit committee and served on the boards of 16 companies while he was serving on the board of directors of Enron. What strikes you about that?
Well, for one thing, how can you adequately really provide support for 16 boards at the same time? That certainly speaks to how much time he would have had to really be able to understand and follow the decisions that were being made by the management team in order that they can provide effective oversight.
Exactly right. And so as you select your directors, you must ensure that they have the time to devote to the job. What was said of the Enron's board? Enron's directors had raised too few questions and challenged too few assumptions during its many meetings with management. It was a board that routinely relied on Enron executives and Anderson partners for information, but took scant effort to verify it. The board quickly approved management's risky steps and illicit partnerships, and then exercised too little oversight of the execution that followed. And look at what that board, thank you, Christy, you can take it down. Look at the impact that the board had because it did not properly execute its oversight responsibilities. Look how many people suffered, how many people lost their life savings, lost their livelihoods. And so the point I want to make this morning is that being in that boardroom, whether as a director or as a secretary, this is a real job. It is an important job. It is a critical job that impacts lives, and we cannot take it lightly. One of the things that came out with all of these corporate failures was the fact that you needed to separate the chairman from the CEO. And you can understand why. Those are two different jobs. The chairman and the board do a different job to the executive team. And I'm so glad when Nigel mentioned that a while ago. I was so happy about it. The chairman and the board need to be looking forward. They need to be looking for what opportunities are coming down the tubes. They need to be looking at what threats could be facing the organization. The management team is busy dealing with the operational issues. And if you read Professor Garrett's brilliant book, The Fish Rots from the Head, you will see that he has these two pyramids, which shows that the board sits there in the center and it looks at the external environment and ensures that it is conversant and aware of what is happening in that external environment, while at the same time overseeing and being fully knowledgeable about what is happening within the organization. So it sits there in the middle and it's the crossroads. And there are you as the secretary, sitting there with that board as an officer of the company under the Companies Act, and helping that board to discharge its responsibilities. So we spoke about board selection. We've selected our directors. What do we have to do after we select them? And I want to hear somebody's voice or see a face. Can I see a face answering that? What do we do after we select our boards and we have our board members? Sasha. And Sasha is paying me no mind. Who else is there who thinks they know? Who is
Just have a hand up. So let's hear from Francis.
Oh, Francis, great Francis.
So I'm exempted then. Sasha was going to answer, but I'll let Francis take the lead.
No, Sasha.
No, oh, okay. Go.
I can answer afterwards. Sasha, you go ahead.
Sure, I don't. Okay. After selection, well, normally then it would be I don't know if you want how detailed you need to get, but after selection and inviting them, do you mean appointment or do you mean just identifying who they should be when you say selection?
Right. So by selection, we've done up our competency profile. We've selected our directors and they're now appointed. So we've filed the notice at the company's office, they're appointed. What's the next important thing that we as company secretaries must ensure?
Well, that they are fully oriented into the organization. Well, what I would normally do is provide them with all the necessary documents that give a profile of the organization, the important documents that might guide their actions, their decisions, the bylaws, the structure, the policies that might affect them, whether insider trading, conflict of interest. So a full orientation program, they may even meet some of the senior management officers in the organization. Hopefully I'm on the right track. If I've gone wrong, please let me know, because I've been doing it wrong a long time. But
Sasha, you've been doing it right. You're perfect. Francis, tell me, do you think Sasha was right?
I think Sasha was perfectly correct in what she was saying. They need to be fully inducted, fully oriented, so that they can hit the ground running as fast as possible, so that you don't have people floundering and wondering what's going on. Part of that orientation should be not just to add to what Sasha was saying, a lot of the information too has to be around culture of the organization. So not just the formal policies and procedures, but also culture, because culture eats policy and procedure very easily. So sometimes the two are not necessarily aligned, or sometimes you just have to be aware of what is going on and how people act and relate to each other. What are the expectations of the chairman, the CEO, the interplay, etc. And just the culture of the board and the organization is very, very important. And sometimes it's very good as well to have meetings. That also helps. So as part of the orientation, if you have meetings scheduled with the new directors and the chairman, your CEO, senior management, perhaps also with your external auditors as well, and your internal auditors as well. So meetings, site visits, documentation, just bringing them up to speed. And it's better to do that in phases. So don't try to put everything in one session, but try to put it in phases so that at least they don't feel overwhelmed, because it's one thing to inform them and orient them, but you don't want to disorient them with too much information, is what I would say.
You thought I was joking when I said I was going to have co-presenters this morning? No, that was brilliant, Francis. Thank you so much. So induction is absolutely critical. Directors have a huge idea. And we have 2 comments on the chat. Right here in the Caribbean, we have the CLICO debacle and the lack of board oversight. So we had our own Enron, and I need to build that in when I'm talking about it in future. And Rafia, so thank you for that, June. And Rafia said, expose them to the company to build knowledge of the business, director onboarding. Yes. So we in this room, we know what we are to do. And it's so critical because directors have fiduciary responsibilities. And what I find is that we say the words, but do we really understand what those words mean? Directors, if you look at the law, the common law, as well as the Companies Act, it sets it out. The words are there, and we've read them so many times, that the directors have a responsibility to ensure the best interest of the organization. What does that mean? It means that when you sit there as a director, the organization's best interests are what are paramount. In Jamaica, we have it both in the Companies Act, and on the public sector, we have it in the PBMA. And the words are, every director and officer of a public body, and the same applies to our private bodies, shall, in exercise of his powers and performance of his duties, act honestly and in good faith and in the best interests of the public body. Exercise the care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances, including but not limited to the general knowledge, skill, and experience of the director or officer. Companies Act, Section 174. Every director and officer of a company in exercising his powers and discharging his duties shall act honestly and in good faith with a view to the best interest of the company. Directors have a fiduciary responsibility to ensure the long-term health of the business. And Professor King spoke to that yesterday so brilliantly. And we would have seen those situations where company has done well and the shareholders want a huge dividend. But the persons sitting at that board know that you need to invest in new equipment. You need to ensure that you modernize your factory so that you can take your company forward. So you know that that money that the shareholders may be salivating over has to be reinvested in the company. And so the directors sit there and their primary responsibility is not to that shareholder who may have nominated them, but to the company and to act in the best interest of the company. That is what the law requires that those directors be. And you as a secretary are in that fortunate position where you have to ensure that your directors understand their fiduciary role, because very often we get persons to serve who have never served or who don't understand these concepts, or the worst ones, they think they know, but guess what? They perhaps don't really know. So what are these other responsibilities? Yes, those directors must promote the success of the company. They must exercise their independent judgment. They must exercise reasonable care, skill, and due diligence. They must avoid conflicts of interest. They must not accept benefits from third parties that could affect their duty of care to the company. They must declare interest in proposed transactions. So you as a secretary, you have to be the repository of this kind of knowledge so that you can ensure that your directors are sufficiently informed. You must be able, well, I don't know about you. I always sat beside my chairman. And there were times when one or two of them would say out loud to the meeting, Camille, stop kicking me. Because I would just give them a little kick under the table. This is when they were saying things which were, no, you can't say that. No, you can't go there. You cannot say that. I don't care what the law says. You just can't say it. Think it, but don't say it. So you are there as that secretary to guide your directors who are not steeped in the world of governance or the law as relates to the company secretary, the corporate world as you are. Expose them to the company, benefits, gifts. What happens to the company secretary if directors don't declare fees? So that takes me to another thing that I wanted to talk about. What happens when they don't listen to you? Have any of you had that problem where you are trying to guide the board, but they are not listening for whatever reasons they may have? This goes back to the need at the get-go to make sure all your directors are on the same page about their fiduciary responsibilities. So when you start to talk, they don't think that, oh, Christopher is just coming with this, or Kenny is trying to make my life difficult. They need to have, at the induction, been made aware that companies have limited liability, but you as a director, your liability is unlimited. And when I speak and share my concerns, I am trying to protect your house and your car and your child's university college fund, because I, as a secretary, it is part of my job to ensure that you discharge your role and function as a director in the correct way. So at no point in time can you be successfully accused of negligence. And certainly fraud is not something that we tolerate in this organization. So the question was, what happens to the company secretaries if the directors don't declare these? Well, you would have had at the start a declaration of interest form that you would have given to your directors and said, directors, please declare your interest in these various, whatever companies. So I declare as a director on a board, we just list all the companies that I'm involved with, because there may come a time where the company is doing something with an entity, doesn't come to the board, and you want, as the director, to have stated upfront, these are the entities that I am related to. Now, if you have a director that is taking gifts and not declaring it, you can't be held responsible. That director would have gone through training as a director to know that there is a procedure for declaring his interests, that he ought not to accept gifts from major suppliers and a variety of people. And if that director then, despite knowing the systems and the processes that you as the secretary have ensured have been established, there is nothing you can do about it. You will have discharged your responsibilities. And in fact, we have a case in Jamaica now where there was an entity that did certain things that were not correct. And when you talk with the corporate secretary, she is extremely passionate because she said all the systems were in place, all the processes were in place. And I told them, and in fact, they did not receive my sharing very well and got quite abusive. But where are those directors now? They're now front page in the daily papers here. They're now before the courts. And I'm sure they're saying, why didn't I listen to my secretary? So the thing is that you have got to at least give the directors a chance to be aware. No, you can't do any of this if you don't know your job. So that is another fundamental principle. You must know your job. You know the laws, you know the governance principles, because the board is depending on you to provide them with guidance. You must be able to answer the questions that they have about the business, so you need to know your business, as well as about the laws. The UK code says the company secretary should be responsible for advising the board through the chairman on all governance matters. How are you going to advise if you don't know? So you got to know, right? And yes, again, going back to Professor King, I mean, anybody who missed it, you need to try and catch up with that little presentation. He spoke about the new social and environmental and sustainability measures, not just the financial measures that are now going to be used to measure companies. You as the company secretary, you need to be up to date on ESG and all the S's, so you can take that into the boardroom. It's your job. So you have to keep yourself informed. How do you, secretaries, how do you, my brothers and sisters in this field, how do you ensure that you keep yourself up to date? Is there anybody who has anything that they think the group would benefit from hearing?
There are two questions in the chat to you as well, Camille, that I think are really interesting. So we can take that as well as you ask for persons how they deal with the situation.
Okay. So, and the first one is, how should the corporate secretary treat with board leaks? So in their induction, you're going to explain the whole concept of confidentiality, right? And after that, if it becomes known, then the chairman will have to speak with that director. And if it persists, perhaps that person should not be on the board. But the first thing is to explain to people the responsibility and the duty, because too often we put our directors in positions where we have not explained to them what they can and they can't do. Should the corporate secretary in those circumstances insist that their advice be included in the board minutes? That's a very good point. What I have found is if the corporate secretary, and yes, and remember now, as the person responsible for the minutes, you are extremely powerful, right? Yes, we record. I see that laughing. Yes, yes, yes. And minutes, that's a whole thing that we could talk about for a day, right? Because let's just go through the little rules. You give enough of the background to contextualize what you're saying, but you capture the decisions. If anybody dissents, that dissent must be noted, right? What I have found with my boards, and I've been very fortunate, my chairman always listened to me, even if they're telling me to stop kicking them. Some of them say, all right, Camille, say it to everybody, what is it I'm doing wrong or whatever? But that comes out of the fact that you have built the trust over the years, where they trust you because they think you are knowledgeable and you know, and you are seeking to protect them. Now, I've never had a situation where I have had to minute my advice. But I would think that if that were to be the case, I would be minuting it, because guess what? When the Auditor General or when the auditor goes in and looks at what has transpired, you want it to be abundantly clear that you gave the right advice to the board. At that point in time, however, I think you'd be dealing with a situation where the relationship has broken down, as had happened with that person that I told you about, and where those directors are now before the courts. So the usual way for handling it is for you to have a one-on-one with your chairman and say, Chairman, I'm really concerned about this. This is why I'm concerned. I don't think we can do it this way. And the chairman would say, well, this is my view on it. And you come to some kind of an agreement as to how the organization is to go forward. What you also find happening, or what happened with me, is that if I said something, if the chairman was kind of brushing it off, usually another director would weigh in and say, but I'm concerned about that too, because you will be providing the guidance and helping to give voice to other concerns. Now, this corporate secretary cannot take over the meeting, and you cannot be, constantly interjecting. But you have to know where that balance is, where you say, Mr. Chairman, the board may not be aware of this, but there is new legislation coming. This is what I think in the circumstances. What some of our boards have also done is, in every board session, there is a little section where we deal with governance issues. So it allows for the constant training of the board, and usually it's the company secretary who leads that particular session. So if it is that there is a particular issue, like you want to explain to them the difference between conflict of interest and conflict of duty, and what does independence really mean, you may do a little session on that. And so some boards build that into every meeting, or some of them have it like every quarter or in those kinds of frequencies. So Kenny's question, I am endorsing Kenny's question, and Kenny's question is, how should the CS treat with the board leaks? And as I have indicated there, that is going to have to be a matter that is dealt with by the chairman once this is identified, and it's made known to those directors that they have a duty of confidentiality, because maybe that person, if this continues, has to be asked to step down. The other thing I want to mention is that
could I just mention on board leaks, because I've had an experience of a board leak, and obviously what we started with was what you said, that the chairman basically spoke to all of the directors and said that there had been a leak. I was then asked, this was many years ago, we were all staying in a hotel. I had to actually then go down to the switchboard of the hotel and see if they were able to print off a list of who had phoned what numbers from what rooms. And we did identify one director who appeared to have phoned a number that was connected with a newspaper. We were actually in the US at the time, in the newspaper, it was a London number that somebody recognised. But we actually then got the internal auditor involved, because we felt they had kind of the investigative skills and obviously was used to being confidential and reported to the board to actually help us investigate it further, to the extent that we then were able to sit down, or the chairman was able to sit down with the particular director and say, look, we have this evidence, you know, how can you account for yourself? And the director then did admit that he had spoken to a journalist about this particular issue.
Alison, thank you for that. So we now have to add private investigator to our list of responsibilities. So yes, I mean, so I have, again, never had to encounter such a situation where you didn't know where the leak came from and had to now conduct investigations. But again, it goes back to the point. The directors have to be made aware that they can't operate in certain ways. The other thing I want to suggest to you is that you are to establish systems. You are responsible for compliance, and much of this compliance happens at set times. A lot of it is like Christmas. It comes the same day every year. I cannot fathom how people can turn up and say, oh, I am late. No, if you know that you have to file your financial statements with the stock exchange by X date, then you know that the draft audited statements have to come to this particular board meeting, and usually it's the same board meeting every year where they need to approve the draft audited financial statements. And if it has to go to the board on that date, then it would have had to go through the audit committee that reviewed it and the finance committee by X date, and therefore working back from that, the auditors would have to have finished it by Y date, and therefore if the auditors have to finish it by Y date, then the audit has to start by A date. There is a rhythm and a cycle to this business. You need to understand your rhythm and your cycle and have your systems in place, so you are not running around like a chicken without a head, trying to explain to the stock exchange why this thing is late. Or worse yet, when you're supposed to be doing your annual report, you know, you don't have the information that you need. So have checklists, right? In Jamaica, we have the disaster risk management orders now, and certain people can't do certain things. Rick's Cafe, big enterprise in Jamaica, and have this huge party in each of the orders with hundreds of people that they're not supposed to have. And then what do they find? That their spirit license has expired and they don't have a license in place to even have 10 people there, much less all these people, and now they're prosecuted. As the secretary, have you looked to see that your systems are there, that things that need to be renewed are renewed on time? Do you have a contract database? I'm not saying that you actually have to do it, but you have to certainly know who is responsible for ensuring that your company remains in compliance. So systems, checklists, annual calendar. So at the start of every year, you all know, we send our calendar out to our directors to say, these are the dates of the meetings. But you should also have those dates on your calendar where you know what is going to happen at each meeting. You know that my risk appetite, the board is going to review, they have to review the risk appetite annually to say, yes, you know, we're still happy that this is this entity's risk appetite. What board meeting are you going to do that each year? So plan ahead. It makes it helps you to ensure that everything that is to get done gets done. Also have ways of doing things. What do I mean by ways of doing things? Let me give you an example. You are responsible under the law for the seal. You have custody of the seal. You execute documents under seal. I always operated in a particular way. I had my seal book. In those days, we got a book, and we entered in the book the name of the person who the parties to the contract, and we initialed who was signing it. And documents were always signed by a director and the secretary, or two directors. If you woke me up in the night and asked me, is how you execute a document, I would tell you this is how we execute a document. So I had to go to court once. And I had somebody there telling the court that, oh, he was authorized to execute the document on the seal. And I am like, no, you can't have been authorized to execute the document on the seal because we have a particular way of executing documents. So that could not have happened. And I put it to you that as secretaries, we need to have ways of doing things so that we sign hundreds of things. We will do a particular thing many, many times. So sometimes you can't remember the particular incident, but what you will remember is this is how I did things. So if somebody said that is how it was done, then it can't have been done that way because I never do it that way. So I have found that having ways of doing things, establishing systems, having calendars, these are things that have made doing the job something that, made me function better. The other thing that is hugely important is the board agenda, and we touched on it a little bit. We have to ensure that management does not hijack the meeting. If it is, yes, and we know the board has to have oversight, but if there is a proper delegation of authority, then the board has reviewed and said, yes, we are comfortable with management approving contracts up to this value. We are comfortable with management doing, all staff hires except for the internal auditor and the company secretary. The board sets out what it has delegated to management in the delegation of authority. And the board also says, but there are some things that we reserve for ourselves. Obviously, under the law, we have to approve the financial statements. We can't delegate that. But if it is anything that's going to have a huge PR impact, we want that to come to the board. If it is expenditure over a certain sum, we want that to come to the board. So you agree what is to come to the board. And that is part of your meeting. But then part of your meeting has got to be that other part of the job where you are foresighting, where you are looking forward. If you are a housing company, you are looking at the process of printing now, the 3D printing and all the other kinds of printing, where they're even printing body parts. Are they one day going to be printing houses? AI, artificial intelligence. We're in which revolution? The world is clearly going through another, whether it is a fourth or fifth revolution now that we are now going through. Is your board being given the opportunity to look ahead and say, in this industry, this is what I think is going to happen? And Professor King, he said there are other things that need to be on the board agenda. He says inputs to outcomes. Because of all that is happening with climate change and all the environmental issues, boards now have to be concerned about what their product may be doing to the society. So yes, you are inputting this in the society. What is the outcome? And this seems now to be tied up in that whole shell case. That is now something that's being discussed and will probably come up later this week. IT governance and cybersecurity. Any board that is not looking at IT governance and cybersecurity is not properly discharging its responsibilities. You as the secretary, you are guiding the chairman and saying, Chair, these are things that we have to find time to discuss. The supply chain, risks and opportunities of climate change. Those were the things that Professor King mentioned yesterday. So putting it to you, consider standing agendas, consider what has to come to the board monthly, what comes quarterly, what comes annually, and therefore plan which months they're going to come in. And then that open space, that white, clean white board where the board has an opportunity to look strategically. The matter of confidentiality and the board leak, and I had it down here as a point. And the point I'd make to you is you must earn the trust and confidence of the board. And sometimes this can pose a conflict for you and your relationship with management. I had a situation where I had perhaps 8 CEOs in 10 years. And you as a secretary sitting in that boardroom, you would sometimes know when somebody's time is coming to an end before that person even knows. And you have to be sure that you are confidential, that the board can trust you with anything. If you have an issue, you will speak to them, but nothing will ever come from you that is inappropriate. 2 ears and 1 mouth. My mother used to tell me that all the while. Camille, you have 2 ears and 1 mouth. She thought I needed to be told that a lot. So with the secretaries, we need to ensure that we are confidential. And that takes me into the point of the working relationship with management. And many of you are probably going to string me up now. But it is my view that we have to get the matters arising out within 24, not more than 48 hours. And there's good reason for that. Remember, your board papers have to go out 7 days before. So that's like a little 3-week window. If you don't tell the executive team right away that the board needs A, B, C, and D, then there is not going to be enough time for them to get that information. So it's not going to get back to the board. And we're going to have to go to the next board meeting and say, oh, it's being worked on. It will come in a month. No, get out the information right away so management has a chance to do what it is the board is asking and to take the steps that the board, the decisions that the board has decided on, and the board has an opportunity to get the information that it is requiring. No, minutes were done the very next day after the board meeting. And why is that? Because if I have to go through and deal with matters arising and then go back through and write the minutes, that is double time. And then this practice now where we all record these meetings means if you spend 5 hours in a board meeting, you're going to spend another 5 hours again to listen. No, you're going to now spend a much longer listening back to that tape. So where many persons are now, you sit in that room with a laptop, and I have had recording secretaries who do that, and they just capture those decisions right away. And by the next day, my minutes are done, and then we draw the matters arising out of that. I find it so much more efficient. So I would block the day after my board meeting to just get the minutes done and out of the way. Each person has to decide how they will handle that aspect of things. But one thing I want to say to you is that you are to remember that your minutes, once they are signed by the chairman, are evidence of the proceedings at that meeting. So if you have a recording, you need to destroy that recording after your minutes have been approved and signed. Because when you take those minutes, which captures those decisions, and you circulate it to the board, and the board goes through and everybody agrees, yes, this is what has happened at the meeting, and your chairman signs that, then there must be no other evidence that stands contrary to that. That is what everybody agreed happened at the meeting, and those were the decisions thereat. So I've been a little concerned about all of these tapes floating around about, with all of these confidential, because, and remember how things float in a boardroom. Somebody says something, somebody says something else, and you go back and forth until you make your decision. And what is captured is that decision with a little bit of the background. So those are some of the things I also couldn't close without mentioning.
There's still a few things in the chat for you to look at.
Okay. Yes. Okay. I was just talking about closing the formal part. So should the corporate secretary no, okay, so let me go down to the end. Oh, all right. Let's see where we communicate or have a board communication policy. Perfect. And it is required in public sector now. A board and stakeholder communication policy is one of the things that is stipulated in the corporate governance framework for public bodies that must be in place for public bodies in Jamaica. And certainly the various codes that we have speak to this. Should there also be a relationship between the corporate secretary and the internal auditor? That is an interesting question, but I would say yes. And in fact, there has to be a relationship, a good working relationship between the corporate secretary and the entire management team. I always was considered a part of the executive management team. Well, I was also head of legal, so that would have brought me in there in that capacity. But that corporate secretary, she is the bridge, he is the bridge between the board and the executive management team. So I think it is critical that the corporate secretary have a good relationship with the CFO, with all the senior managers, and definitely with the internal auditor. So my answer to that would be yes. I have a corporate governance calendar to make sure that the regulatory reportings are met on time. Very good, June. That is how I operate, and I don't see how anybody can operate without that. Delegated authorities need to be clearly defined, if not contained in the incorporating document statute, as well as signing authorities, as if not correctly done, can invalidate documents, definitely. So that takes us to the point, ostensible authority. If somebody is held out by an organization as having ostensible authority, the court will say, or could very well say, yes, your entity is bound because that person was held out as having authority. And so that company needs to ensure that there is a clear delegation of authority. So say in banking, you know that the branch manager can approve loans up to X dollars, $10. And then after that, it has to go to the credit committee, which can go up to $100. But above $100, it has to go to the board. So it's clearly set out as to who is authorized to do what. And I find that where there isn't a clear delegation of authority, management is also hampered because they don't know what they can do without coming to the board, and it wastes the board's time and management is not as effective. So there must be a clearly articulated delegation of authority that says, yes, management, you can do this without coming to the board. You can spend so much without coming back to us. You can spend up to what we approve in the budget. But if it's outside of the budget, you have to come back to us, right? So, and to the point of that relationship, the UK code speaks to it as well. It says, under the direction of the chairman, the company secretary's responsibilities include ensuring good information flows within the board and its committees and between senior management and non-executive directors. So it's part of what we are responsible for. And we all know that we're responsible for the board evaluation. That is now a critical responsibility. In Jamaica, there is now a corporate governance index. And this index measures the compliance of entities against the corporate governance code. So there is a committee that looks at how our publicly listed companies are operating. And we gather a lot of this information from the annual report, from the website, and then the companies in Jamaica complete a questionnaire, and then they are scored, or listed companies are scored AA, BB, C, and that is the score that's ascribed to them for their corporate governance practices. Now, we haven't got to the point where we're making it public, but it's going to eventually get there.
Faye also has her hand up. Camille, I think she wants to make a contribution.
Hi, how are you? Yes, I realize we're kind of like getting close to the time. So I wanted to, and we didn't address this topic, which is this question when you mentioned that you also the head of legal, because that's also my experience as a company secretary. It is a very, I would think, a very common one for a certain generation, certainly our generation of company secretaries. But more and more, there's this thinking coming across that the role of the company secretary has become so enlarged and has become so much closer to, say, the support of the board and the chairman, that the role should be separate, and you should not have this kind of joint role is not encouraged. So I wondered what your thoughts on that might be.
I agree with you. And it goes back to the point about the evolution. So when I started, that was fine. But now today, I can tell you it is a challenge to do both, because if you have a matter in court and you have some corporate secretarial functions, you know you have to go to court, right? And so what very often happens is the corporate secretarial functions play a secondary role to the legal function. And where governance is today and the role and the responsibilities of the secretaries today, I no longer think it is sensible to join them. Unless, of course, some people still say you can have a support team. So the person who has the role of corporate secretary and legal, she wouldn't be the one going to court. It would be one of the lawyers in her department, which, yes, okay, that is a structure. And so if you have that level of support, then I think you can. But like in our corporate governance framework, now on the public sector side, that is frowned upon. It is the thinking is to separate the roles. And so I completely understand, Faye, what you are suggesting, and would love to hear other thoughts. Alison.
Yes, a couple of things. I've been a company secretary for too many years, when the company secretary's department was actually in finance. So if you go back into, pre-1990, when we started to see regulations, we were part of the finance department. One of the challenges with the lawyer being the corporate secretary, and we've seen case law on this in Australia, and there have been discussions in other parts of the world, is that firstly, if you're in the boardroom as the company secretary, you're not there as the legal person. So any legal advice you give, if you're asked to give legal advice whilst you're in the boardroom, is apparently not covered by legal privilege. So you need to be very careful that you kind of caveat everything you're saying by, I'm saying this as the governance professional or as your company secretary. And if they're wanting you to give legal advice, you'd need to say, we need to do that in a different forum, which can obviously create issues potentially for you. We used to kind of get round it by saying, well, if you have a job description that says this is what you're doing as the company secretary and this is what you're doing as the in-house lawyer, then that's fine, because you can then say, well, I'm now acting with my hat as the company secretary, so this is what I'll be doing and this is what I can do for you. The court in Australia actually said, no, you can't split a person in half. And if you're the legal officer, you have a responsibility to identify and manage legal risk. So if you're sitting in the boardroom and something comes up which is a legal issue, you need to tackle that as a lawyer, not as a governance professional. So it's adding on really the complications of having a dual role, particularly if it's a lawyer and the company secretary. And then obviously there's always been this conflict that, as the governance professional, you're supposed to be doing the right thing, making sure that the board is doing the right thing and managing reputational risk. Whereas if you're there as the lawyer, you have an obligation and responsibility, if you like, to the CEO, who's often your boss, to actually deliver on maybe cost-cutting activities or, deliver on the minimum standard, which is the laws, complying with the laws and regulations. And it might put you in a conflict situation with the CEO who is trying to meet targets, financial targets and things. So there's many different reasons, I think, why combining the role, whether it's with legal or something else, or specifically issues around combining it with legal, that I think we need to be thinking about these days.
Alison, thank you for that intervention. I would love if you would send us that case. You weren't perchance suggesting that lawyers aren't doing the right thing. No, of course we were not. We could not be suggesting that. Faith
Well,
was to say,
Yeah, I,
we do try to do the right.
you know, is a minimum standard,
Yeah.
and society is way and above.
I just want to say, I'm not necessarily pro that view. I think there are a lot of issues, and if you are, because sometimes there is just, the company doesn't have the funds, the resources to separate those roles and have a full-time secretary. So sometimes you're forced to join the roles. So I think also, you know, there are a huge array of issues that if you are the company lawyer, you need to be aware of, and you need to be very capable of managing that kind of, you know, those kinds of conflicts as they come up. But I think also, you know, this idea that you're the lawyer and you report to the CEO, I don't know, I must be a different generation of lawyers. I think in-house counsel need to be independent, and they don't just do as they're told. And I read a recent article with respect to Tesla, where the Tesla had a bit of a revolving door when it came to chief legal officers, because they wouldn't do what the boss wanted, or you know, they didn't agree with some of that. And the board was actually found to be, I wouldn't use the word negligent, because being a lawyer, negligence has a particular meaning, you know, but the board was taken to task for not giving more independence, more recognition of the need for independence of the legal person. So I think it's less about separating the roles, but more about giving the legal head of legal that support for the independence of that role, to be able to do the right thing exactly as you said. That's what you expect to do.
Yeah.
So that's my little contribution, but I absolutely agree. It's a minefield, and you need to be careful.
Thank you, thank you. Julie James is on. Julie, you're on the spot. Julie had both roles, head of legal, corporate secretary for Scotiabank. Julie, are you going to ignore me?
It's always tricky getting back on.
Yes, I'm not hearing her. I'm not hearing her. Okay. She was
Hi,
on.
hi, it's Brendan King here.
Oh, hi, Brendan.
Hi, I was deputy chair of that board at Scotiabank. I just want to say that Julie did a great job. Always very professional, very clear with her advice and counsel. And, you know, the board welcomed that and certainly didn't, you know, respected the division between the legal and the corporate secretarial role. And she did a great job in both. And there was obviously lots of complexity involved in it, but, you know, everybody respected the boundaries and looked for her guidance.
Okay, right. Thank you for that. Thank you for that intervention. Yes,
It
Camille.
seems to me a bit, Camille, as though it is the corporate secretary who has to really carve out that relationship with the board to demonstrate the independence of the position as well, so that the board gets an understanding that, you know, it's not just about carrying out whatever instructions that are done at the decisions that are made at the board level, but rather understanding that each person in their professional capacity may be able to offer input and guidance based on whether they think that that particular decision or guidance may lead to something that's not a good outcome for the organization. So a corporate secretary who is also the head of legal in a department, to my mind, can contribute significantly to how the board views the role by the way in which they carry it out.
I agree with you. And I kind of think that's what Brendan was saying as well, because Julie did a great job doing both things. And very often it does benefit. There are benefits to the company when your head of your corporate secretary, you know, has that dual role. But I take the point that's being made by Alison, and Alison is going to share that case with us, because it's certainly something in the Caribbean that we will have to look at. And certainly just from the basic operational side of work volumes, I can tell you it is an issue now when you it can be an issue when you have the two combined. And Kenny's saying, so if there is a company secretary at the board and the company has a head of legal, who has the final say at the board level? The directors have the final say at the board level. The head of legal will provide their opinion and their advice, which is now to the point that's being made by some of our participants, that you know, have on your legal hat, you do your legal research, and you provide a legal opinion. But at the end of the day, either the management or the board will make their decision as to what they wish to do. And the secretary now, she's giving advice as to governance and process. The secretary would not in that capacity be giving advice as to the law. All right, questions, other questions, because we are.
Faye has her hand up again.
Yeah, I don't want to dominate the question, but I think I also, you know, one of the things that I did some research on was this whole question of legal privilege, because it was something that concerned me. I think it's a very interesting and rich field of research, but especially for boards and companies. But I think one of the key learnings that I took away from that search is that you do not take legal advice in a boardroom, because if you're going to have legal advice, have it in a context where, you know, the advice is being given by the lawyer, either to your CEO or your chairman, or the discussions in a boardroom can easily breach privilege if it's not treated properly. Mm-hmm. Because those, if it gets any minutes and it's circulated, so I would say the best rule is not to take legal advice in the boardroom.
Yeah, of course, if you have requested a legal opinion and it's formally presented to the board, mm-hmm. then that legal opinion would be part of what the board takes into consideration in making its decision.
But then you separately manage that discussion as a privileged discussion, because it's dealing with this legal advice rather than in the context of the whole meeting. It's actually, I mean, it actually also leads on to the whole different concept of having a lawyer on your board. And is the lawyer on the board to give advice? And if the lawyer gives advice in the boardroom, is that privilege? You know, so it kind of opens up a lot of interesting discussions about what role are you acting in. And I see Francis wants to add to the discussion. Mm-hmm. So I will wrap up.
Yes, because it is a practice whereby many boards will ask for legal opinions, and that legal opinion will form part of the basis of their decision making. So I don't see how you could add, and I don't think you are saying that the board should deprive itself of the ability to get professional advice, because it is entitled to get professional advice. Yes, Francis.
Yes, I just wanted to add to it. I mean, being in that situation now, and I know Faye for most of her career was also in that particular situation as well. It is a juggling act, and you have to be very careful about when you give advice. It is useful, you know, as someone brought it up, it's in the structure. I think it was you, Camille, who spoke about having support beneath you as well. So like, if you can avoid you yourself giving advice to the board that comes into the boardroom, and you're a very senior person, of course, you can review the advice, make sure it's blessed, etc., etc. But the document, if you can avoid having your name on it, you know, but the board knows tacitly that, look, you as the senior person would have looked at it, because the fact that it's coming to the board means that it's an important issue. So for the purposes of the board, your name is not on the actual document. So that's one of the ways that you manage that. And as the secretary as well, I think Kamala said it, it's up to you to really, I don't want to use the word train, but educate your board on the risks of that dual role that you're performing very early on. In particular, your chairman should be aware of that, so that it almost becomes part of the culture, where you may even find, before you have to say anything, a director may say, wait, hold on, why are you asking Francis this question now? So it really is something that should be ingrained in the culture of the boardroom, and the corporate secretary, who is also the head of legal, should really take steps to ensure that is part of the culture, and that everyone understands that, and that you shouldn't be called on the spot of on the spot to give legal advice, because you happen to be the legal professional in the room.
definitely. So is that another thing to add to the induction?
Yeah, exactly.
Ladies and gentlemen, we are now at 11:33. Kamla, this is the end, right?
Yes, yes, it is. So, and for persons who are confused, Camille is an hour away from us, right?
Oh, sorry, 12, sorry. Yes, yes. So sometimes I join late for things, just because of that, right? Or early, right? Whichever, I get confused. Yes. All right. So I just want to wrap up now and say thank you all. Thank you to all my co-presenters. You see, all of you didn't know you were going to be co-presenters. And I have really enjoyed sharing this afternoon or whatever, this day, hour and a half with you. One of the things that was once said, and something that I just want to close with, is that many of us as secretaries have to bear in mind that very often we serve on those boards longer than those directors. Directors have term limits. Corporate secretaries, as far as I know, unless one of you know that's something else, I don't know, we don't have term limits. And so you bring to that board institutional memory and knowledge that can be so critical to their functioning. And somebody just once described a corporate secretary as a wise friend, and that stuck with me. So yes, when you're there whispering to the chairman and saying, that's not a good idea, if he thinks of you as that wise friend who's been there and has knowledge and he trusts you, then you are invaluable to that chair and to that board. So thank you very much, Ms. Kamla, for asking me. And here endeth the proceedings.